Welcome to today's webinar brought to you by the Online Ultimate Guide to State Drug Testing Laws at statedrugtestinglaws.com, a service of WFC and Associates. WFC and Associates is a national consulting firm that specializes in drug testing policy development and providing accurate and up-to-date state drug testing law information. The Online Ultimate Guide to State Drug Testing Laws is the most comprehensive and up-to-date state-by-state guide to drug testing laws on the web. An annual subscription gives you easy-to-use, online, and password-protected access to the individual state drug testing law information that you need when you need it. Today's sponsor is Alere Toxicology. Alere is a leading provider of drug and alcohol testing services to the workplace, criminal justice, consumer, and clinical markets. Alere offers state-of-the-art laboratory services at a number of locations across the country, including 2 SAMHSA-certified facilities. Alere is also a leading provider of point-of-collection testing products for urine and oral fluid specimen, as well as breath and saliva for alcohol screening. Today's presentation has been approved for 1 credit hour of continuing education from SAPAC for CSAPAs. Further information will be provided at the end of our presentation. Today's presentation is entitled Marijuana, Still Dangerous, Still Illegal in the Workplace, and will be presented by Bill Current. Bill Current is the president and founder of WFC and Associates. Bill works with many of today's leading providers of drug testing and background screening services. He also works directly with the small business and large corporations to help them improve their return on investment in drug testing. He is the editor of the Online Ultimate Guide to State Drug Testing Laws at statedrugtestinglaws.com and the publisher of the e-newsletter State Drug Testing Laws Monthly and the weekly e-news service Drug Testing in the News. He is the author or co-author of 10 books on substance abuse issues, including Why Drug Testing. It will now be our pleasure to hear from Bill Current.
Well, thank you again, Jessica, and it's good to be with all of you today. We've got a pretty good presentation planned for you. I think you're going to, if you've been on any of the webinars that I've done in the past where I've spoken about marijuana, I think you're going to find a lot of new information here. It is a quick developing issue and something that I think is going to continue to develop over the coming months of 2014. A lot of marijuana activity so far in this year. I do want to just take a moment to thank Alere for sponsoring today's webinar, for the work that they do in helping to bring good quality information to the drug testing industry, and for sponsoring this monthly series of webinars. At the very end, we'll have a little bit of information about next month's webinar, but I will tell you a little spoiler here that it'll be presented by Pat Pizzo. And if you've been on any of Pat's webinars that we've done in the past, you know she does a great job with that. So we're looking forward to the one on March 27th. But today we're going to talk about marijuana. We're going to look at some recent headlines, and then we're going to compare marijuana to alcohol, which is what everybody in the pro-marijuana side is asking us to do because they think that's a winning argument. We'll look at whether or not it is. Then we'll look at some legal marijuana laws, medical marijuana laws. We'll talk a little bit about the magnitude of the drug problem, the marijuana problem in particular. But then we'll get into some policy issues, and we'll look at that, and we'll look at some of the major legal decisions and how they affect the workplace. So first off, let's look at some recent headlines. And you're going to notice that President Obama's name is in every one of these headlines. And I didn't do that on purpose. There's no political slant to any of this, but he has really actually been very active on the marijuana issue in a couple of ways. And so we're going to talk about that. And if you read the papers or if you follow the news on the internet, you're going to know that he sort of has made some pretty remarkable statements that have lent a lot of credence to the pro-marijuana movement. I'm not sure that he intentionally meant to do that, but it's had that effect. Recently, he came out and said that marijuana is no more dangerous than alcohol. And he referred to his own marijuana use background, which is fairly well documented, as he admits, and talks about the fact that he does not think that marijuana is any more dangerous than alcohol. And so hence we're going to talk about that a little bit later. But it has really sort of lit up the legalization debate once again, as you can see in the headlines there. And recently, the administration has issued new guidelines for banks that are dealing with legal marijuana dispensaries, whereas normally a bank cannot is not legally permitted to provide its services to anything dealing with illegal drugs or illegal activities for that matter. But some recently issued guidelines for bankers have changed that, and it's paving the way, if you will, for making it easier for the legalized marijuana dealers to do their business. And there's still a little bit of confusion on it, but it's one of the things that you want to keep an eye on. I think that second to last bullet there is also very, very interesting. With all of the sort of loosey-goosey references to marijuana, I won't say pro-marijuana because I don't think that's what the president's doing, but making these statements that really sort of lend credence to the movement. He's now being urged. This is not new, but it's sort of been reignited. He's now being urged to reclassify marijuana as a less dangerous drug. As you know, now it is a Schedule I controlled substance, and that places it at the top of the list of dangerous drugs. And while there are typically in each Congress those who will come forward with a bill to reclassify it, Obama's being urged to essentially tell the Department of Justice to reclassify it. And there's some question not whether the Department of Justice can unilaterally do that, but that's the latest movement. And so the president has talked about the fact that he doesn't think it's as dangerous as alcohol, and in terms of its impact on the individual consumer, he considers it less damaging than alcohol. And so let's take a look at marijuana and alcohol in just a couple of areas. And you can do this. You can make these comparisons in a lot of different ways, a lot of different issues. I'm just going to look at two. I'm going to look at driving, and I'm going to look at addiction, because these are the two that if you go onto the pro-marijuana website, they make quite a fuss about these. And so here's some of the latest information about alcohol. A new study came out that showed even a slightly, quote-unquote, buzzed driver, somebody with a BAC of 0.01, meaning they've maybe just had one drink recently, are 46% more likely to be at fault in a crash with a sober driver. So that's pretty interesting, right? Because part of the argument with marijuana is that you smoke a joint and, you may test positive in an oral fluid test because it's going to, with oral fluid, the window of detection opens up immediately. So you're going to probably test positive in an oral fluid test, especially if it's a lab-based oral fluid test at the lower cutoff levels that lab-based oral fluid testing can detect at. But how does that compare to alcohol? One other stat down there at the bottom, in 2010 there were over 10,000 people killed in alcohol-impaired driving crashes, which accounted for nearly a third of all traffic-related deaths in the United States. Okay, so there's alcohol and driving. Now let's look at marijuana and driving. A recent study came out that showed that marijuana-related traffic fatalities had tripled over the last decade. And they only looked at these states, California, Hawaii, Illinois, New Hampshire, Rhode Island, and West Virginia, because those are states where they keep statistics on the toxicology level of fatal car crashes. And in those states, they found that the marijuana-related traffic fatalities had tripled in the last 10 years, and that up to 2010, and that coincides actually with the real momentum in the legalization of marijuana in a number of states. Now, Illinois just recently approved marijuana for medicinal purposes last year, so you really can't count that in for Illinois. But California, Hawaii, yes, absolutely. New Hampshire was new the year before, so really not part of this. It's interesting that in these states, the rate had tripled. The alcohol, if you look at the next paragraph, alcohol contributed to about the same percentage of traffic fatalities. So when people talk about marijuana and alcohol being the same, or that they should be treated the same, I would point to those statistics and say, well, then we just have to be prepared for the consequences, because Alcohol contributes to about the same number of traffic fatalities as marijuana, and alcohol is legal right now. So once we legalize marijuana, where will those traffic fatalities figures go after that for marijuana? Absolutely, it's going to go up. And so, and we see that as an argument in some of the states that have marijuana laws, that, you know, as you legalize marijuana, you're absolutely going to see more traffic fatalities, and you're going to see more accidents in the workplace. Now, on the subject of addiction, one of the main arguments for the marijuana people is that marijuana is not addictive. I mean, plain old not addictive. And so when you compare it to alcohol, it's interesting to note that I'm looking at some of the messages here saying that the slides aren't moving, and so we'll try to correct that here for you in a second. And Jessica will be working on that. In the United States, nearly 14 million adults, or every 1 in 13 adults, abuse alcohol or have an alcoholism problem. That's significant. And I see that Jessica's just starting to catch up with us here. So let me get you on to a couple more slides, Jessica. Right there. Go back one slide. Okay. Basically what it's saying here is that alcohol is very addictive, and there are a lot of people addicted to alcohol. I think we all know that to some extent. Now, if you go to the next slide, you'll see that marijuana long-term, and this is from NIDA, this is the National Institute on Drug Abuse, long-term marijuana use can lead to addiction. This is the conclusion from the National Institute on Drug Abuse, which is an agency within the federal government. That is, people have difficulty controlling their drug use and cannot stop even though it interferes with many aspects of their lives. Sounds a little bit like alcohol, doesn't it? It's estimated that 9% of people who use marijuana will become dependent on it. The number goes up to about 1 in 6, that's about 15, 16% in those who start using young in their teen years, 25 and to 25 to 50% for those who use marijuana daily. That's fairly significant, right? So you look at the addiction rates for alcohol and then look at this report from NIDA, and it would seem like, yes, that's true, Mr. President. Alcohol and marijuana are actually pretty similar. Marijuana perhaps no more dangerous than alcohol, but alcohol being very dangerous on the roads, people under the influence of alcohol, and highly addictive, and it turns out marijuana mirrors alcohol in both of those particular areas. Now, this is not a political statement, okay? I just happen to be someone who believes that marijuana is not a safe drug. It's not a benign substance, and those who are under the influence of marijuana in the workplace pose a greater safety risk, not to mention being less productive than those who do not use marijuana. And the magnitude of the problem is fairly significant. If you look at that second bullet there, marijuana was the most commonly used illicit drug in 2012, according to a report issued by SAMHSA's National Survey on Drug Use and Health. 24 million Americans in the survey, 12 and older, admitted to past month illicit drug use, and the vast majority of them, about almost nearly 80%, were marijuana users. And so that is significant. Now, there are other drugs, of course, that people are using besides marijuana, but marijuana accounts for the majority of it. It accounts for the majority of positive drug test results in the workplace. And so if you've got increased rates of accidents that are related to drug abuse, then it would correlate with the percentages of people who test positive for marijuana. There's just no way around that. It's just an indisputable fact that people under the influence of marijuana in the workplace are less safe, and they're more likely to be involved in a workplace accident. This is an interesting chart. I've showed it many times before. If you've been on any of my webinars, you probably have seen it. And I use it usually to sort of highlight the fact that psychotherapeutic drugs like tranquilizers, sedatives, and other prescription medications are the number 2 class of drug abuse in the United States, second only to marijuana, and that it's catapulted over cocaine. But by comparison, marijuana is still by far the number 1 drug of abuse in the United States. It still accounts for the illicit drug that most people use. And then there are also statistics that show that a big majority of people who use illicit drugs only use marijuana. It's the only illicit drug that they use. And among young people, as you can see to the far left, that blue column represents psychotherapeutic drug abuse by young people, 12 to 13, the number one drug of choice for those people that are about to turn teenagers. But then by the age of 14, and certainly by 16 and 17, marijuana becomes by far the most abused drug by young people. And that sets a dangerous precedent for their adult drug use patterns. As they come into the workplace, they're typically coming in, large percentages are coming into the workplace with experience using marijuana, and some of them are addicted to marijuana. They use it every single day. Now, I've got some statistics in this report for those of you who are interested in getting the slides afterwards. I'm not going to go into all of those, but these are interesting. They show the levels of employees who are current illicit drug users. We know that, and this is just one source, Drugs in the Workplace from NCADD.org, but this is just one source of many that show the effects of drug abuse on workers, on the workplace. And this is interesting only, again, because you could make the claim that these individuals are under the influence of cocaine or they're using inhalants, but the truth of the matter is the vast majority of them are using marijuana, and in some cases they're only using marijuana. They may also be using alcohol as well, but among illicit drugs, marijuana is the number one drug of choice, and it results in these types of behaviors and work performance. Some of these are things that happen in people's personal lives that are, a result of their drug use behavior, and it makes its way into the workplace. There's just, no way around it. I'm not going to spend a lot of time on these next two slides. They're the statistics about workers' comp claims and accidents in the workplace. I think this is all stuff that we've seen many times before, but it's interesting. It's certainly relevant to the discussion. People who are marijuana users are not only more likely to be involved in a workplace accident, but also more likely to file a workers' compensation claim, to switch employers during the year, to get fired or to leave. There are statistics from the federal government that show that people who use drugs are less likely to work for a company that does random drug testing, for example. 40% of illicit drug users say they would prefer not to work for a company that conducts random drug testing. Well, that's certainly no surprise, right? There are the statistics, but they tend to go to work for companies that don't do drug testing. And there they find a safe haven to pick up a paycheck and perhaps be at work under the influence of marijuana. And so those statistics are sort of indisputable, and it costs money. There's just no way around the fact that a substance-abusing employee is going to cost his or her employer more, according to a Navy study, just in lost productivity and replacement costs, than an individual who doesn't use drugs. And while the overall number is in the billions, I think it's really that $7,000 per user number that makes the most sense. It's something that we can all relate to. If I have 100 employees and 15% of them are drug abusers, then those 15 workers, right, 15% out of 100 is 15 workers, are costing me $7,000 a year. That's a significant cost to a small business. And so that's the number we really need to pay attention to. Now, in today's presentation, I'm going to talk about legal pot, and then I'm going to talk about medical marijuana, okay? Kind of two different sides of the whole marijuana issue. I'm not going to talk today about synthetic cannabinoids, which is another part of this issue. It seems like it maybe shouldn't be related because it's synthetic drugs, but there is at least one study that I know of that Pat Pizzo has used in some of her presentations that talks about the fact that there's a fairly significant percentage of young people, high school students, who will switch to synthetic marijuana when they know a drug test is coming up so they can get by the drug test without having to stop using a drug. And then once the drug test threat passes, they go back to using real marijuana. Now, when it comes to legal pot, we're talking about laws like in Washington and Colorado, where it's been legalized by voters for what's called recreational use. And so when that happened back in around Christmas time of 2012, the president went on national TV with Barbara Walters and said, we've got bigger fish to fry. It would not make sense for us to see a top priority is going after recreational users in states that have determined that it's legal. Now, of course, that's picking and choosing which laws you're going to enforce and which ones you're not going to enforce, because marijuana is still illegal under federal law. It's a Schedule I controlled substance, so it's still illegal, and there should still be some responsibility or obligation on the part of the federal government to enforce those federal laws, even in states where it's been legalized, like in Colorado. The intent during the whole campaign to get voters to vote in favor of legalizing marijuana back in 2012 was to treat it similar to alcohol. That was the campaign in Colorado. And so we've looked at some statistics that compare marijuana in Colorado. I'm not sure that the voters in Colorado looked at that very carefully, but they passed it based on that campaign. It was like a marketing campaign, and it was something that worked in Colorado. It's perhaps going to be used in other states that are considering recreational marijuana laws, and it may work in those states as well. But it's important to point out that, yeah, if you want to look at marijuana and alcohol, they're both the same in the sense that they're both dangerous. And so if you put the real facts in front of people, I think it resonates with them. But in Colorado, they voted to legalize it. It is legal for people 21 and older. They're not allowed, supposedly, to use it in public, although we see reports of that often in Washington and Colorado. They can only possess up to a certain amount, of course. And in Colorado, that recreational marijuana law, the legal marijuana, legal pot law, actually contains a statement on the workplace. And I think this is interesting. Nothing in this section, in the law that was passed, is intended to require an employer to permit or accommodate the use, consumption, possession, transfer, display, transportation, sale, or growing of marijuana in the workplace, or to affect the ability of employers to have policies restricting the use of marijuana by employees. Now, this is a very important statement as you and I look at having a drug-free workplace policy and a drug testing policy and how we're going to address marijuana. I've got a section of this webinar presentation coming up towards the end that where we're going to talk about that in detail. But usually what you'll see in a lot of these medical marijuana laws, and there are 20 states now, plus the District of Columbia, that have legalized marijuana for medicinal purposes. But you'll see statements somewhat like this. And usually it'll have some statement in there that's supportive of employers when it comes to not being required to accommodate the use or consumption of marijuana in the workplace. That doesn't mean, however, that an employee can come to work under the cannot come to work under the influence of marijuana. And the courts have started to become involved in this situation because there have been individuals who have been terminated for testing positive. And their argument is that, yes, I did use marijuana, but I used it legally, and I was not under the influence while at work, or I wasn't impaired while at work. That's usually the terminology, impairment as opposed to under the influence, that the marijuana, that the pro-marijuana folks will use on this. But Colorado's language here takes it a step further, where you start after the word or, right there on the third to last line, or to affect the ability of employers to have policies restricting the use of marijuana by employees. It does not deal specifically with where that use takes place or when that use took place. And this is going to factor in very significantly when I talk a little bit later about some of the major legal challenges that have so far gone in favor of employers, but you're going to see some challenges coming up that are going to go to the very heart of that issue, and we'll talk about that about 10 or 15 slides from now. In Washington, they passed a similar law to Colorado, very similar, a little bit different. Okay, they did already have a DUI level, 5 nanograms of THC, before the passage of this law. And they consider that to be the equivalent of a 0.08% blood alcohol content level for driving under the influence. You may have remembered on the previous couple of slides back, Colorado did not have that. They have since added that to their law, a 5 nanogram per milliliter THC cutoff level for essentially a DUI, but it's a DUI for THC rather than rather than alcohol. Washington already had that, but what Washington didn't have, and they still don't have, is any sort of language in their marijuana law that helps to clarify essentially what employers can and cannot do when it comes to prohibiting employees from using marijuana at work or using it on their lunch breaks or things of that nature. That still does not exist in the Colorado law, or excuse me, in the Washington law. You'll see that most states, not every one of them, but most states with medical marijuana laws have some type of language like that in them. And the two medical marijuana laws that were passed last year in Illinois and New Hampshire are very interesting. They take the whole workplace part of this issue to a whole new level. But we still have some ambiguity when it comes to Washington, the state of Washington, that is. Now, in terms of Washington, D.C., the Department of Justice has issued a statement early on when it related to medical marijuana that it will not be a priority to use federal resources to prosecute patients with serious illnesses or their caregivers who are complying with state laws on medical marijuana. Again, sort of acquiescing to the state law despite the fact that the federal law says something completely different, okay? The Department of Transportation, however, has said, we don't care what your excuse is for using marijuana. You cannot use marijuana if you're a truck driver, for example, that falls under the federal regulations, under DOT regulations. And as it says in the second paragraph, medical review officers will not verify a drug test as negative based upon learning that the employee used recreational marijuana. So the medicinal marijuana issue, the recreational marijuana issue, despite the fact that some states have passed recreational marijuana laws, it remains unacceptable for any safety-sensitive employee subject to drug testing under the DOT drug testing regulations to use marijuana. And so that's sort of the other side of the coin when it comes to the federal regulations. The Department of Justice, we're not going to be aggressive on this. The Department of Transportation, we're going to be aggressive on this. And so sometimes it kind of creates a little bit of confusion for employers who maybe find themselves, regulated by the Department of Transportation, but in a position where they're in a state where it's been legalized, where marijuana has been legalized. And so what do we do about that? Well, the bad news is there are a lot more recreational marijuana laws coming. In 2013, you see the far left side of that slide there, there were quite a number of states that looked at marijuana laws. And the ones in green are the ones that have already passed medical marijuana laws. So it's, sort of fertile ground for the pro-marijuana people in Hawaii, Maine, Massachusetts, etc. They already have medical marijuana. Last year they looked at legalizing it for recreational purposes. In 2014 so far we've got bills in Alabama and New Hampshire, but the Marijuana Policy Project, which is the one of the leading advocates for the legalization of marijuana, they are projecting publicly that Alaska, Arizona, California, Oregon, and the District of Columbia will all legalize marijuana this year. They're projecting, perhaps predicting, but based on their efforts in those states, they are projecting that marijuana will be legal in those 4 states plus the District of Columbia before this year is over. That's a pretty bold statement. And we're not just talking about medical marijuana. We're talking about legalizing marijuana generally. When it comes to medical marijuana, these are the states that have legalized it so far. And as I said, it's 21 total because we're counting the District of Columbia in there. The 2 states that passed laws most recently are Illinois and New Hampshire. I'm going to talk about both of them in a second because the workplace provisions of those 2 laws are unique compared to some of the other states. In 2014 so far, we are looking at medical marijuana legislation in these 14 states. 14 states as of right now. And if you look down at the source at the bottom, this is under the Marijuana Policy Project, what they call Bill to Create Effective New Medical Marijuana Laws. So these are the ones they like. They like how these ones are written. They're in favor of these ones. And if you're in any of these states, be forewarned. Now, this is the list of states, 8 more states, right, that if you look at the bottom, these are bills that fall short of comprehensive effective laws. These are 8 states that are looking at legalizing marijuana for medicinal purposes that do not meet the standards of the Marijuana Policy Project. So these are states that are considering actually legalizing it, but not to the extent that the pro-marijuana people would like to see. And so this is actually a list of 8 to go along with the list of 14. So we're really looking at 22 states that are looking at marijuana legislation this year. And every state has its own, legislative season. And if you've dealt with state legislatures, they have many, many issues that they're dealing with, and they do it, sort of part-time in a way. and they're only in session for a short part of the year. So the intensity of the lobbying on the marijuana issue is going on right now. As we reported at the end of 2013, as we put up the list of all the states that had state legislation in 2013, most of them had been crossed out because either they had died in committee, they had been voted down, and in many cases they're never voted on because the marijuana people, their supporters will pull the bills or they'll stall the bills if they don't think they have the votes to kind of help the bill progress. But this early in the year, a lot of these are still very active. In fact, I think, if I go back to this list, I know Iowa, I believe in Iowa the bills have already died in committee. That may be true in some of these other states. In New York, very interesting in New York, yes, there is legislation in New York, but the governor of New York, Governor Cuomo, has already announced that he's going to legalize marijuana for medicinal purposes by executive order. In other words, he's going to bypass legislators if necessary and never even give voters an opportunity to vote on it. He's already signaled that with or without the support of the legislators in the state of New York, he's going to find a way to legalize it by executive authority. So we're probably going to see medical marijuana in New York before the end of the year. Now, we know that one of the common things among all of the medical marijuana bills and those that have been passed and become laws is that it intends to decriminalize the use of marijuana by people who are ill and the caregivers who take care of them. And so it removes state-level criminal penalties for people who use it, possess it, or cultivate it. In California, it's interesting because you only need, the bar is set really low. You only need an oral recommendation from a physician that marijuana might help you with whatever your ailment is. Very interesting in California, a lot different than other states where you're required to be a registered medical marijuana user and you have to have a written recommendation from a physician. And you may be noticing that I'm using the word recommendation as opposed to prescription. Because marijuana is a Schedule I controlled substance, doctors cannot prescribe the substance. And so if you go and you look at what the definition of a Schedule I controlled substance is, it's a substance that cannot be prescribed. There's no known medical use for this drug. And so it's interesting that on the one hand, the pro-marijuana people are advocating marijuana as a way to alleviate some of the ill effects and side effects of certain types of illnesses. On the other hand, they're admitting the fact that, it's illegal federally. Their whole argument is that it shouldn't be, but working within the parameters of the federal law, when you see these pro-marijuana laws, whether it's medical marijuana or recreational marijuana, but for the medical marijuana people, they never talk about prescribing marijuana. It's always recommending it because they know that word prescription will get them in trouble. It'll kill a bill before it ever gets out of a committee in a state legislature. And we've seen that happen in a number of states where the bill never got out of committee because someone made the mistake of using the word prescription or prescribing marijuana. And of course, that would be a violation of the federal law. A long list of legitimate medical conditions. You'll find cancer, multiple sclerosis, maybe diabetes, things of that nature. But in California, you find the term other chronic or persistent medical symptoms. That could be stress, anxiety, panic attacks, whatever. And it's just sort of a catch-all phrase that you will find in many medical marijuana laws and many medical marijuana bills. Now, I told you I was going to tell a little bit about New Hampshire and Illinois. In New Hampshire, in the new medical marijuana law that was passed last year, it contains this language: nothing in this chapter shall exempt any person from arrest or prosecution for A, being under the influence of cannabis while, 1, operating a motor vehicle, etc., or 2, being under the influence of cannabis while in his or her place of employment, without the written permission of the employer. So, and then you see number 3, operating heavy machinery. That could also be a workplace situation as well. But isn't that interesting that nothing in the law is intended to exempt a person from being arrested or prosecuted if they're under the influence of cannabis at work, unless they have the written permission of the employer. And I don't know how often you're going to get that, right? But New Hampshire takes it a step further. Nothing in this chapter shall be construed to require any accommodation of the therapeutic use of cannabis on the property or premises of any place of employment. And this chapter shall in no way limit an employer's ability to discipline an employee for ingesting cannabis in the workplace or for working while under the influence of cannabis. The pro-marijuana people, that's not one of their favorite phrases right there. And so in time, you'll see the New Hampshire legislators looking at amendment language to this, because this creates a giant loophole for employers, right? This is right in the wheelhouse of drug testing. Certainly, we can all agree that individuals should not be allowed to ingest cannabis in the workplace. But the argument, the real crux of the argument, is working while under the influence of cannabis. Well, years ago, the courts determined, from a legal perspective anyway, that a drug test does not prove or show impairment. But an employer can define what under the influence means in his or her workplace. And one of those definitions can be testing positive. So because the language is so loose here, employers in New Hampshire can probably very legitimately claim that an individual who tests positive could be considered by company policy under the influence, and then subject to whatever the consequences would be in that particular company's policy. I think we're going to see a challenge to that, because it plays right into the hands of some of the court cases that have been decided in Michigan and Colorado, for example. Now, Illinois is a little bit different than any other medical marijuana law in that it has specific references to zero tolerance and to drug testing. Let me show you. Nothing in this act shall prohibit an employer from enforcing a policy concerning drug testing, zero tolerance, or a drug-free workplace, provided the policy is applied in a non-discriminatory manner. I think there's, probably some room for argument in terms of the application of non-discriminatory. But when it talks about being applied in a non-discriminatory manner, I think that's drug testing everybody the same way, or drug testing them consistent with law or consistent with, certain scientific standards that have been established, whether you're doing urine testing, oral fluid testing, hair testing, etc. That's probably one of the strongest statements of support in any medical marijuana law that exists in the United States. It goes on to say in Illinois, nothing in this act shall limit an employer from disciplining a registered qualifying patient for violating, that should be, a workplace drug policy. That's interesting because it really sort of goes in lockstep with a legal decision, really a landmark decision that came out of Michigan, and then later one from Colorado. So a little bit about Illinois and New Hampshire. Interesting that these two states have these kinds of protections built into their medical marijuana laws. Not ideal if you're in the pro-marijuana movement. You probably are not happy with this language, but it's what they had to agree to, at least initially, to get medical marijuana passed in Illinois and New Hampshire. And you'll see them coming back in time to try to correct that language. But this is what it took to get the business community not to vigorously oppose these two bills. Now, I did refer to court cases. Let's look at three of the major ones, okay? We've talked about these in the past. Joseph Casillas, brain cancer patient in Battle Creek, Michigan, who worked for Walmart and was fired after testing positive for marijuana. Now, Mr. Casillas was a registered medical marijuana patient in that state, and he claimed that he never went to work under the influence or high on marijuana. Walmart's policy doesn't care why you use the drugs or where the drug came from. It does not condone the use of marijuana for any reason, and the courts actually agreed with Walmart. And this is directly from the statement. The fundamental problem with Casillas' case is that the medical marijuana law in Michigan does not regulate private employment. This is a big, big issue right here. When the pro-marijuana people got this bill passed in Michigan, they did not put in language to restrict employers from being able to take action, adverse employment action, against an employee who tests positive, even if that employee is a registered medical marijuana user. Goes on to say all the law does is give some people limited protection from prosecution by the state or from other adverse state action in carefully limited medical marijuana situations, but nowhere does the law state that the statute regulates private employment, that private employees are protected from disciplinary action should they use medical marijuana, or that private employers must accommodate the use of medical marijuana outside of the workplace. This is really landmark. This is really given attorneys all around the country who are going to be trying to defend companies that take action against a worker who's tested positive and been disciplined for testing positive for marijuana, even though they may be in a state where marijuana is legal. So you're going to start to see, again, language that sort of closes this loophole, what the pro-marijuana people would consider to be a loophole. They're going to come back and they're going to start to challenge this kind of protection where the private employment community, like Walmart, are sort of outside of the protections that are built into some of these medical marijuana laws. In Colorado, there was a gentleman by the name of Brandon Coates. He was an employee of Dish Network. He tested positive for marijuana and was terminated. He was a legal user of marijuana in Colorado. And this all initially transpired anyways, before Colorado voters legalized marijuana for recreational use. Mr. Coates was using marijuana for medicinal purposes, okay? He sued to get his job back, but the trial court dismissed his claim in 2011, and the judge agreed with Dish, claiming that medical marijuana use was not a lawful activity covered by the law, even though medical marijuana was legal in the state of Colorado at the time. Now, in 2013, a court of appeals struck down Mr. Coates' appeal, and this is what they had to say. Because activities conducted in Colorado, including medical marijuana use, are subject to both state and federal law, for an activity to be lawful in Colorado, it must be permitted by and not contrary to both state and federal law. We've been talking a lot about the fact that marijuana is a Schedule I controlled substance. That's why it's so important to know that. But we're going to see a big, giant challenge to that. The Colorado Supreme Court has agreed to hear this case, to review this case, and it's now coming to them as a violation of the state's legal activities law. In Colorado and in many other states, they have what's called a legal activities law, which means that an employer, in this case, cannot discipline an employee for using marijuana, medical marijuana, legally, and then testing positive for it later. And so the two main issues are whether the state's lawful activities law protects employees from discharge, right, for the lawful use of medical marijuana when that use took place outside the workplace, right, because most medical marijuana laws restrict employees from using marijuana while at work, even for medicinal purposes. But what this is challenging is that the state's lawful activities law would protect that individual when the individual can show that they are a legal user of marijuana, that they use marijuana outside the workplace, and then, as it says in number 2, that they have the right to use medical marijuana to persons lawfully registered within the state, and that it doesn't affect their job performance. And that's a big part of the issue. It's only fair that we look at all the different studies and reports that are out there, because there are some out there from various sources that minimize the effect of marijuana on the user in a safety-sensitive environment. There are just as many studies out there that show just the opposite, that individuals under the influence of marijuana are less safe in doing certain functions that require motor skills, like operating heavy machinery or landing an airplane, or perhaps even operating on a patient if it's a doctor. And so it comes down to whether or not, we're going to allow individuals to be under the influence of marijuana as defined by the employer, which is testing positive, or whether or not employers aren't going to have that right anymore. And one of the things that we've talked about during the different webinars that we've done through StateDrugTestingLaws.com, and today, of course, sponsored by Alere, is try to alert the drug testing industry and the employer community that if you don't start paying attention to these things, you're going to wake up someday and drug testing for marijuana is going to be illegal. Now, it's not, and we're going to talk about that here in a second, but that's the direction that this whole issue is heading in right now. Now, there is one other case that's important, Roe versus Teletech. This is a Washington state issue. The Washington Supreme Court actually upheld a lower court's ruling stating, quote, medical use of marijuana, the Medical Use of Marijuana Act, which is the Washington medical marijuana law, does not provide a private cause of action for discharge of an employee who uses medical marijuana either expressly or impliedly, nor does the law create a clear public policy that would support a claim for wrongful discharge in violation of such a policy. And that's coming from a fairly liberal state like Washington. So we have so far as an employer community won the big cases. I would say that in Colorado with Coates versus Dish Network, the jury is now out again because it's going to go to the next level. And I would imagine that if the Colorado Supreme Court rules in favor of Mr. Coates, that perhaps it will then go to the Supreme Court, to the U.S. Supreme Court, and that will definitely have an impact on the entire strategy of the pro-marijuana people and perhaps inspire employers to get a little bit more involved in the issue as well. Let's talk about how to address marijuana in a policy. Whether you're an employer listening to this webinar today or you're in the drug testing business and you deal with employers, these are important points to keep in mind. For your policy, and we're talking about marijuana, but it could apply to other issues as well, you've got to be clear. Your policy has to state precisely what types of behaviors are prohibited, what kinds of consequences will result if somebody tests positive for a prohibited substance. And you list what those drugs are. What are the drugs that you're going to test for? You list those in your policy. Some state laws require that, but even if you're in a state that doesn't require it, you're in a state that doesn't have a drug testing law, you still need a comprehensive policy that articulates the prohibited behaviors, the drug testing method, who it's going to apply to, and under what circumstances you're going to test, like pre-employment versus random testing, for example, and the consequences for violating the policy. And you've got to be clear about that, especially when it comes to marijuana. The policy should state that the use or possession of marijuana in your workplace is prohibited, despite the fact that it may be legal in the state in which you're doing business, and that the detection of any amount of marijuana by the cutoff levels that the company uses would be considered a violation of the company policy, and those consequences would then kick in. Okay, and we're running a little bit short on time, so let me skip ahead because I want to share some sample policy language with you. Keep in mind, I'm not advocating this particular language. You would have to modify this on a state-by-state basis anyway, but here's a general statement. There are three sections to the statement: the basis for your position, the prohibited conduct, and the consequences. Okay, so the basis of your policy on marijuana is the company recognizes that some state laws permit the use of marijuana either for medical or recreational purposes. However, the federal government continues to classify marijuana as a Schedule I controlled substance, thus making it illegal to use for any purpose under federal law. So that's where your authority comes from. We're simply complying with the federal law of the United States, which considers marijuana illegal. Now here's the prohibited conduct. Employees are prohibited from being under the influence of marijuana while at work or on company time as exhibited by a positive drug test result. You are defining under the influence of marijuana as, among other things perhaps, testing positive for marijuana. Employees are prohibited from bringing marijuana or any marijuana-related paraphernalia to work or using marijuana while at work, including, and be specific, lunch breaks and other time off during an official work schedule. So that's what's prohibited. You're very clear. You've left no wiggle room there at all. And here are the consequences. Employees who test positive for marijuana, regardless of the reason for the use or the source from which the employee acquired the drug, will be considered in violation of this policy and subject to possible adverse employment action as outlined, and then refer them to the consequences section of your policy. And in that you'll have consequences for pre-employment positives, first-time positive. If there's some wiggle room there, maybe a second-time positive. You'll have language on suspensions in reasonable suspicion and post-accident scenarios, for drug test cheating, adulteration, etc. But all of your consequences will be in that section, and it will then refer them to that consequences section. Well, why not spell it all right out in the open here in the marijuana section? Because, again, we want to treat everybody the same, non-discriminatory policies. So for consequences, you're just simply going to refer them to the consequences that apply to all employees of the company regardless of the drug that they test positive for, regardless of what element or component section of the policy they've just violated. In this case, they've tested positive for marijuana. But when you go to your consequences section, it's not exclusive to marijuana. It's violations of any of the sections of the policy. And your prohibited conduct section should be, if you're going to list them in bullet format, it's going to be several bullets long. Okay, it's going to have lots of different things in it. Now, remember, if you are mandated by the federal government to conduct drug testing, you must test for marijuana. If you fall under the DOT regulations, your drug test panel must include marijuana. If you're mandated by a state government agency, you most likely must test for marijuana. You'll see that in some states, like in Illinois, for example, they now have a medical marijuana law. In Illinois, if you're in the public works business and you have a contract with the state, you have to drug test, and your policy, your program has to mirror the DOT regulations. And so in some states, the state government will have a mandate in place that requires you to test specifically for marijuana. If you're located in states without legal marijuana laws, the legal marijuana laws in other states do not apply to you. So if you're in Texas, for example, and you're fretting about the marijuana law in Colorado and Washington, and you don't have any employees in those states, you don't have any business operations in those states, then I would say stop worrying about that. You have to comply with the Texas law, and there is no medical marijuana law in Texas at this time. If you're located in some states with legal marijuana laws and in some without, you're not required to impose the legal marijuana standards in the states without such laws. So you would modify your policy to comply with the marijuana laws in the states that have marijuana laws, but you're not under any requirement at that point to impose those same standards in the other states that you do business in that do not have marijuana laws. If you're located in a state with a medical marijuana law, check the law to ensure compliance. And it's important to note, like we've talked about, most of these medical marijuana laws have some type of language in there that protects employers from, disciplining a worker who has come to work under the influence of marijuana, or disciplining a worker who has used marijuana while at work. If you're in Washington and Colorado, you must still comply with the DOT regulations that require testing for marijuana. I hope that's clear. I hope that, and I know there's confusion on this because I hear about it. In Washington and Colorado, if you're an employer that falls under the DOT mandate, you're not exempted from testing for marijuana just because it's legal in Colorado and Washington. The DOT regulations still require, even in Colorado and Washington, that you test for marijuana. But regardless of where your business is located, it's important to acknowledge the fact that marijuana is illegal under federal law. You are still required to test or to consider marijuana illegal. So I'm going into my conclusion now. And I wanted to point out the fact that earlier in this year, in the year 2014, I used this statement that was on the National Office of Drug Control Policy website, ONDCP, which is an extension of the White House. It used to be, I'm not sure if it still is, it used to be a cabinet level position many, many years ago under the first President Bush, I believe. Marijuana and other illicit drugs are addictive and unsafe, especially for use by young people. Second paragraph, marijuana contains chemicals that can change how the brain works. Addiction, respiratory and mental illness, poor motor performance, and cognitive impairment, among other negative effects, are the result of using marijuana. Well, I looked and looked and looked, and I could not find the statement on there. If you can find it, email me and let me know, because I don't want to disparage ONDCP in any way, but I could not find this statement just 30 days later. It's possible that it's just a rotating, website, and it's no longer there. Excuse me, but I couldn't find it. The Marijuana Policy Project, though, has said that their objective is to legalize marijuana. They have as they call it, a robust plan to legalize marijuana in 14 more states between 2014 and 2017 by lobbying state legislatures and spearheading state ballot initiative campaigns. Here's the prediction. Each of these efforts will help to form a string of statewide successes, and by the spring of 2017, 16 states will have legalized marijuana. Let me tell you, they're not talking about legalizing marijuana for medicinal purpose. They're talking about Colorado and Washington kind of laws. And with each of these state-level successes, we'll come that much closer to ending the marijuana prohibition in Congress, with the ultimate goal of legalizing marijuana nationwide by 2019. I've said this many, many times. It was never about compassion. For the pro-marijuana people, it has never been about helping people with debilitating illnesses like cancer and multiple sclerosis. It's always been about legalizing marijuana generally. And they used the medical marijuana approach because early on, nobody was interested in legalizing marijuana. Now, the emphasis has shifted, and the states that legalize marijuana for medical purposes are now the easy battleground for legalizing marijuana generally. Both Colorado and Washington had medical marijuana laws in place already before they legalized it generally for recreational purposes, sort of the marijuana Trojan horse, if you will. So in conclusion, marijuana is still dangerous. It's still illegal. It's an increasing problem in our country, and laws that legalize marijuana certainly complicate things for employers, but the federal government, at least as I speak right now, still considers marijuana to be a Schedule I controlled substance, meaning it's illegal. And employers have the right to insist that their workers not be under the influence of marijuana while at work, and that written drug testing policy is still the key, as it always has been, to having an effective drug-free workplace program in place. So we've got just a few minutes for Q&A. I do want to point out, though, that Pat Pizzo will be the presenter at next month's webinar on March 27th, which will be hosted by Alere Toxicology. And those of you who are on today's call will be receiving information about that. I did get a lot of questions right at the beginning about not advancing the slides, but hopefully you've been seeing the slides advance. We are looking at a number of different questions here, probably more that I can get to in the first few minutes. Somebody clarifying, though, that the ONDC position was never a cabinet level position, so I probably just misinformed on that, but want to make sure, just in case you have a relative who was the head of ONDCP and you're wondering why he's doesn't have a cabinet level pension plan. That's why. There is a question here, is the EEOC, the Equal Employment Opportunity Commission, or ADA, weighing in on these matters, on the medical marijuana issues? And so far, I haven't seen anything on that. But what's interesting there, of course, is that the Americans with Disabilities Act treats current drug users differently than current alcohol users. So if you're a current alcohol abuser, a misuser, an alcoholic, you're considered a protected class under the ADA, but current users of marijuana and other illicit drugs are not protected. Will that change? Possibly. It's an issue that is still evolving, and I've not seen the EEOC weigh in on this issue yet, but perhaps they will, and when they do, we'll include it in a future webinar. We'll keep track of those things. And let me say also that I spent a lot of time trying to modify today's webinar presentation because I've spoken on the webinar or the marijuana issue many, many times over the last year and a half, and there's just constantly everyday new information. And so it's interesting to look at what's happening in Colorado and Washington, for example, where they're grappling with the tax issue, for example. We could do a whole webinar just on how marijuana is or will not is going to or will not actually generate revenue for the state to pay for things that the state said it was going to pay for once they started selling marijuana legally. So it's constantly an evolving issue. Question here, are there any states you would not encourage employers to have a clear policy on prohibition of marijuana? No, not actually. I would say that in every state, employers should address the issue of marijuana directly. Now, there are a lot of states that are very conservative, that are not looking at medical marijuana laws, but you saw even the state of Utah, perhaps the most conservative state in the country, was on that list of states that are looking at medical marijuana in 2014. It was on the list of states that the Marijuana Policy Project wasn't pleased with, but even in Utah, there's legislation to consider legalizing medical marijuana. So I would say address it everywhere. What is your position on employers dropping THC from employee testing panels? And I would say, this will be the last question of the day, I would say no, don't drop it from your drug testing panel, but look at ways to test for marijuana in a smarter way. I've done a whole presentation, and if you know me, you know I'm a proponent of drug testing in any possible way. If you do it right, any drug testing program can work for you. But one of the advantages to lab-based oral fluid testing is that it's got that shorter window of detection, and most importantly, the window of detection opens up immediately after someone ingests a drug. So it mimics blood in that sense as a detection method for marijuana. And you're going to be able to catch people who use marijuana in the parking lot on their lunch break with an oral fluid test a lot easier than you will somebody with a urine testing program, where you're going to have that lag time of about an hour before the drug appears in a urine specimen. And of course with hair, you've got a 7-day lag time, but then you've got the 90-day window of detection. But with oral fluid, yes, it's a shorter window of detection by comparison, but you've got that immediate ability to detect use. So I would say all drug testing programs work if done right, and some of them are going to be perhaps a little bit more ideal for marijuana use. Anyways, thank you for joining our webinar today. Thanks again to Alere Toxicology for sponsoring this monthly series of webinars. And with that, I'll turn the microphone back over to Jessica.
Thank you, Bill. On behalf of the Online Ultimate Guide to State Drug Testing Laws at statedrugtestinglaws.com and Alere Toxicology, we hope you have found today's presentation informative and helpful. This presentation was recorded, and you will receive information informing you on how to access the recording. Today's presentation is approved for 1 credit hour of continuing education from STAPAC for CSAPAs. Please email Jessica Polk at jessica@billcurrent.com. That's JESSICA@BILLCURRENT.com if you are interested in receiving that credit. Thank you for your attendance. This concludes today's webinar.